Our next panel discussion is on global risk mapping, leveraging your due diligence and mitigate multi-jurisdictional risk. To discuss this, I would like to welcome on stage Leila Sassi, Head of Legal Middle East at Natixis, Saloni Tuteja, Head of Legal Middle East at Servier, Edith Nordmann, Managing Partner, Attorney at Law ACG International. Please welcome them on the stage.
Hi, everyone. So by way of introduction, my name is Leila Sassi. I'm heading the legal function at Natixis for the Middle East. So for those who doesn't know Natixis is the investment banking arm of Group BPCE, which is the second largest banking group in France. We are located in the GIFC. We have a subsidiary in Saudi, which is a CMA-registered entity. We have a rep office in Egypt. And we operate really in all the Middle East and in some designated countries in Africa as well. So I've been with Natixis for 9 years. I joined from Citibank Dubai, and I've been in the region for 18 years. A little bit about myself. I'm a civil law qualified lawyer. I speak Arabic, and I'm quite familiar with English law contracts, being in the banking industry for a long time. So over to you, Edith.
Good morning, everyone. Well, first of all, welcome to my co-panelists, being happy on an all-female panel. Today, we had quite some male people before, and on the ESG panel, it was said that we women would feel how things go. We'll see about that in such a topic as due diligence. My name is Edith Nordmann. I'm, as already said, I'm a lawyer and I'm the managing partner of ACG International. At the same time, I'm the chairman of the Netherlands-India Chamber of Commerce and Trade and part of the workforce for the B20, sustaining the G20 in Delhi at the moment, of the task force for the future of work, skilling and mobility. I'm very excited to being here on the panel.
Hi everyone, we'll try not to exceed time because we know we all are hungry a bit. My name is Saloni. I am head of legal for Middle East region for Servier. For people who don't know, Servier is a French pharmaceutical company. While we all are women here, interesting is all of us come from different backgrounds, different nationalities and different industries. So hopefully we'll be able to cater to a lot of interest here. As a part of my background, I am an Indian qualified lawyer. I've done my master's from UC Berkeley. I have been a part of APAC region as well as now Middle East region. I've been a private practitioner and now an in-house counsel. And I would also take an opportunity to thank LexTalk for putting the interesting panel here as well as this very broad topic. And I think we were just discussing, we can speak hours and days on this. Again, we wouldn't be doing that because, like I said, we are all a little hungry as well. And since I have the mic, maybe I'll segue to what due diligence is. And as I mentioned, it's a very, very broad topic. And interestingly, we've always all have been a part of it, both as a subject of being due diligence, being a candidate for a certain job or sometimes matrimonial, or we have been a part of due diligence, being compliance officer, finance officers, or lawyers. Now, what does due diligence mean? And when I was thinking about this topic, I saw this very interesting definition, and let me read this out to you. Due diligence is an investigation, audit, or review performed to confirm facts or details of a matter under consideration. While this is a one-liner definition, I think each word of this definition is very relevant, also busts a lot of myths. And I think we were talking before the panel here is that, is due diligence limited to something that we start before we initiate a relationship, whether it's personal or commercial, or is it something that is ongoing? So that's something that I think we all will talk about here, and we would love to hear your views as well. Now, this concept of due diligence, like I said, has a lot of myth and sometimes also skepticism, specifically from commercial. Oh, due diligence, we wanted to start business now, it'll take months and months. It's going to be very complicated. It is going to hamper our business. They'll ask for so much information. I'm sure all of us have heard these things or said the same things. Now, that's the beauty of due diligence, is it can be as simple or as complex as we want it to be. And it is also highly dependent on the subject matter. It's not one size fit all. It has to be made customized. It has to depend on what we are tackling with. I think that's something which is so important for due diligence, and specifically when we are facing so many myths and so much of pushback. And I must say, we have come a long, long way when it comes to due diligence. It's no more a due care. It's no more good to have, but a must have, much like ESGs and many other concepts. In fact, if we talk about FCPA or UK Bribery Act, it clearly says that it's not only what you do, but also what your partner is doing. It's not what you do directly, but what you do indirectly also. I think all these concepts have made due diligence extremely important. Another thing that, apart from what the regulatory requirements is or what the legal requirement is, it is very prudent to do due diligence. The reason being is it pre-informs us. It somewhere prepares us to, what kind of risks that we are seeing in an, in a matter or in a acquisition or even a vendor. And I think we have plethora of examples. For all the rum lovers, we all would have heard this example of Havana Club, and the constant battle of Pernod Ricard and Bacardi, who owned the IP for Havana Club. The other example I can think of is when Dow Chemical acquired UCC, Union Carbide Corporation. They had to battle years of litigation, and fortunately or unfortunately, I was a part of that litigation. It started almost 10 years back, and today, I think early this year, is when one of the litigation or main litigation concerning UCC got disposed of by Supreme Court of India. So, we are talking about millions of dollars here. We are talking about investment of a lot of time and resources. And somewhere, if we don't do due diligence properly, it takes us back by decades sometimes. So these are just examples of what an effective due diligence can do. Another thing that I hear quite often is, oh, if we do due diligence and if there's a red flag, we'll not be able to do business. I think that's something that we all hear quite often from different team members. That's again something that all of us are always working towards, which is one red flag or one concern does not mean we will not enter into a relationship. I don't think so. That's the intention of why we do due diligence. It's all about understanding what the red flag is, understanding what the concern is, and remediating it. It's a beautiful tool to be proactive and to do analysis of the risk that we may face in the present or sometimes future. So I think I've spoken a lot on why. Now, how can we do it? There are multiple ways of doing it, and interestingly, due diligence is something that can be easily customized, be it different jurisdictions that may be tackling, whether it's we are a part of APAC, whether we are part of Middle East region, Africa, whichever way. Another thing is customization is not only based on the jurisdiction, but also the corruption index of a country, and also what are we looking for? Why are we doing it? I think the why is very important. Is it because we are acquiring a company? Of course, then the due diligence will be much more complex. It will have many parameters, including IP, IT, regulatory, legal, reputational, or it can be a simple one that we want to enter into a consultancy agreement with a government agency. Then our due diligence process may be very, very different. So there is a lot of ways we can change it. Another aspect that always fascinates is, when should we do it? Is it something that, and who is responsible for due diligence? I think both of them have been evolved so much. when I remember, I started with the concept of due diligence in my younger days, and I'm no more that young, is we always thought, oh, we should do due diligence only when we are initiating a transaction. Actually, that's not absolutely correct. I think due diligence is something which is a continuous process. It can be when you're starting a transaction or a relationship, and also investigation. I think that's also part of the due diligence process, and also keeping your ear close to the ground. Any reputational risk that you hear, or any new litigation that you've heard against your vendor, or what was the reason. Every litigation or every investigation may not be as bad. It can be very simple, or it can be some against you have initiated that that litigation. It can be many reasons. So it's always good to be pre-informed. What is that information that we have gathered, and how to intelligently use that information. So those are the reasons, I think, or those are the things to be considered. And it should be continuous. I think I cannot emphasize enough. It cannot be the case, oh, we did due diligence, everything is clear, very hunky-dory, and we are done with the responsibility. I think that's not the case. Sorry, you wanted to say something? No. So,
Yes.
Depending on the red flags that we have gauged, or the corruption index of the country, or the complexity, we can always decide, is it something that we want to do it once in 2 years, or once in 3 years, or maybe that's it. So I think, and I have spoken quite a bit. So again, multi-jurisdiction, customization, and us as legal officers, compliance officer, or finance. I know some people here are also from finance background. I think that's what we need to keep, discussing and evolving. It's not that, we have put a due diligence program in place and our job is done. I think it should really be evolving with the business, with the times. And I think another aspect we were discussing some time back is the relevance of AI, privacy in due diligence, which again is another topic. So I'll hand over to you.
Thank you very much. Well, due diligence, as you said already, it is here to stay, not only here to stay, it is something that we just have to do. It's with us every day, whether we like it or not. Nobody asks us whether we like it or not, by the way. You already mentioned that why are we doing it? First of all, of course, mandatory-wise, we have to. The fines are humongous, so that is one of the reasons, certainly a big trigger to do it. But as we talk about due diligence, nobody's really happy to talk about this topic, and nobody is really happy to do it. I mean, the compliance officer in the company is not the most loved employee of the company, let's put it that way, but one of the most important people with a very important job. So thinking about that topic, the question is actually, where do we come from with respect to due diligence, and where are we heading? Let me take you back a few years. You already said when I was young. Well, let you take me back. You take me back when I was 7 years old. You already said that we are an international group of ladies here today. Very happy to be here in Dubai. So I was born and I grew up in Switzerland. And my grandfather, for my 7th birthday, before that, he gave me pocket money for weeks. He gave me 1 franc every week, and before my birthday, I knew something very important would happen. I had a piggy bank, and all these pieces of 1 franc were in there, collected nicely for weeks and months on it. On my birthday was the big day, 7, a few years ago. So, yeah, definitely. So he took me to the bank, UBS, still existing today, on Paradeplatz, huge bank, marble, everything, very exciting. 1 hand in my grandfather's hand, the other hand, piggy bank. I went to the counter with him and reached up to the counter, put my piggy bank there, and there it was emptied. The pieces of money were stacked, 47 francs, and the lady, the teller, told me, "Good morning, young lady, what's your name?" So I said, "My name is Edith, and I'm here to open a bank account." So the lady said, "Wonderful, Edith, welcome, and thanks for bringing your money. And who is the gentleman you are with?" So I said, "That's my grandfather, and it's my birthday today." "Wonderful." So she took out a little booklet. You probably all know it because we are all above 20, so we all know how you opened a bank account back in those days. The lady would just take a booklet, write the amount in it, sign it, put the stamp, and you would get it back. And that was the amount that you could retrieve from the bank because it was yours on the account. I was very happy with that booklet, very proud of my first bank account. I left the bank with my grandfather, an empty piggy bank, but with a booklet with my account money in the account. Now let's fast forward a few years until today. I can tell you one thing. It is impossible today to go as a 7-year-old girl to the bank with your grandfather to open a bank account without getting a lot of questions. What is the source of wealth? What is the source of fund of these 47 francs? Who are you? Do you have parental consent? Who is this gentleman with you? We need a stack of documents to be filed and to be filled in before a bank even considers opening a bank account. All due to KYC and due diligence. That's where we come from. It was a relation based on trust. The lady at the counter trusted. I didn't have an ID with me either as a 7-year-old. You didn't have to have that. Nowadays, this is impossible. Is it a good development? I don't know. It's also not important. It's where we are at the moment. And where are we heading to? That's the other thing. Let me tell you about a judgment, a recent judgment in the Netherlands of the appeal court where the following was going on. There is a young internet bank with no real offices called Bank, B-U-N-Q. And the Dutch National Bank told them that their way of KYC and due diligence was wrong. Why? What did they do? They said, look, all our customers, just not businesses, but private individuals, they have the same kind of profile. We have one general profile we put on top of our customers, and we use AI to see whether there is anything unusual in those bank accounts. We don't do the entirely onboarding, we don't do the KYC and the DDU as we would do with all other customers and all other clients do, and that's how we do it. Of course, the Dutch National Bank objected to that, and they said, that's not the way we want to do it. We have a law, and there it states clearly that you have to do KYC and the due diligence. But the young bank, young and angry, they went to court and they said, I don't accept this. So it went all up to the highest tribunal in this particular case. And this highest court decided that as the way of checking who they are and how they are, they did have passports and all these kind of things, is not very clear in the law, and therefore there was no proof that what the bank did was wrong. They red flagged crazy things that would go out of the ordinary, and then they investigated, and then they raised the flag, and they said it is a higher risk. The use of AI was okay in this particular case, because what Bank said is the following, and that's actually where we are at the moment. What they said is, look, we do not accept that for doing due diligence, we have to stop every single car on the highway to check the speed of that car. What we do as Bank is, as soon as somebody is speeding, we will take them off, and then we will check. And the Dutch National Bank now said, okay, based on that, we need to change our approach and look into this. So that's a very interesting, of course, they did make some other mistakes for which they were punished. But in principle, we are very happy that this young and angry bank decided to go against the regulator, which is not an easy thing because they are there every day and around the corner. The question is, of course, what should be done and how we can do it to alleviate all these costs and how we can use AI or other means to make it less costly and less labor intensive. Because that's something that we face in the Netherlands with all the financial institutions. It is extremely labor intensive to do due diligence. And as the fines are so high, banks are investing heavily in compliance and in all the workforce that goes with it in order to avoid making mistakes and paying the fine for it. So I would be interested, I know that usually we do questions at the end of such a session, but I would be interested to know whether anybody in the room is using AI for due diligence already. Anyone? No. Interesting. It can be done. So if you're interested to know what they did, bank, to do it, because it saved them a lot of money, and they still use it, and apparently it is admitted. Happy to share it with you. Over to you.
You know, Edith, I'll just give one other example of saving costs. And this, sorry, Leila, I'll just take 2 minutes. So one of the organization that I was working, and the perception was, oh, due diligence will take few months, and sometimes it will get rejected. We'll not be able to work with the vendor. So everyone they could think of, they would put it in due diligence. Now, there are costs related to due diligence and money as well as labor intensiveness as well. So what we did was we started creating a business case. So if before you put any entity for due diligence, whether it's through automated processes, through your compliance officers, you have to create a business case saying why you need the vendor or this relationship or this acquisition. And the moment we started doing it, I think the workload of due diligence decreased to half, because then the team members who were putting those requests were accountable. That's another aspect, I think, which is very important for due diligence is the buck doesn't stop at compliance or legal or finance. I think it's due diligence, and much like compliance or anti-corruption or culture, it's everyone's responsibility. So yes, if tomorrow you can use such a trick to ensure that there is a reason why an entity is being created and gives you visibility as well as the vision. Okay, it'll help you understand how much you need to do due diligence. Because just saying, okay, we need to vet or we need Saloni to vet a certain vendor does not give you information. It does not help you analyze or do the calculation how much information we need from that vendor or sorry.
No problem. So I'll give you an overview of how we conduct due diligence or risk mapping within the banking industry. So risk mapping is the process under which an organization will try to identify, quantify, or put priorities to risk in order to, monitor, for example, the performance, reputation of a company in the course of its activity. So what are the risks that you are trying to mitigate really here? Widely, we can classify risk into 3 categories. So you have business risk, you have financial risk, but you have also operational risk or legal risk. So I'm here to talk about the legal risk. I think it's important as a legal department, to put actions for mapping risk, and we can do it through, for example, the review of all the contract or important documents related to a company, conduct internal interviews or discussion with the stakeholders like senior management, head of business line, risk officer, compliance, like just to understand the risk that they are facing. And then I think we need to identify these risks and put control in place. So the objective really that you are trying to achieve here is, 1, to fight against legal uncertainty due to the proliferation of regulations, 2, identify this risk, manage this risk, and then implement corrective or preventive actions to mitigate this risk. The act of mapping is not really defined by law, so it's really up to each organization to define the methodology they want to follow. we at Natixis, we follow the recommendation of the French Anti-Corruption Agency, which is in line with international best practices. I think the growth or the success of a company will depend on being on the right side of the law. So if you are not complying with law or regulations, you will be facing litigation, which can, you can spend a lot of money and time fighting legal battles, be exposed to heavy fines. That's why I think it's very important to put in place a legal risk management system. So how we do it in the bank, we make sure that we have a full management of all our contracts, which means that before signing any new contract, you need to ensure that you have a proper legal sign-off. The legal department obviously will review the legal clauses like indemnity, liability, governing law, but also you need to ensure that your business will review the commercial terms, and these terms should be in line with what's been agreed with the client. The other thing what we do is monitor deadlines. So we have what we call the calendar deadline. So just to make sure that you are not missing any milestone or deadline important, for example, to terminate a contract or to renew a contract, send prior notice, things like that. The other thing what can be very useful is the automation of certain contracts. So especially if you have a volume, for example, we do a lot of derivatives. So these are standard documents. So using tools that will basically reflect the commercial terms in the contract can be, can help in the legal department. And also, I think e-signature is a good one. And we've seen it during COVID. We spend a lot of time on collecting signatures and checking capacities. So tools like that can really, save time. The other important topic is also, I think, be on top of any law or change of regulations. So I think how we do it in the bank, we have tools that will notify us about any change of regulation that will affect the activity. Then we have what we call a Reg Watch committee. So it's a local committee that will review these law and regulation. And for example, extraterritorial laws that would have an effect on Paris or in US, then will escalate to head office. The other point is to ensure that you have good policies and procedure in place. I think it's very important to keep the same standards within all the different platforms. So of course, within the legal department, we have the code of conduct, we have anti-corruption policy, we have sanctions. So a lot of policies that we need to comply with. And the last 2 points I will say, it's environment law. We know all the importance of ESG and greenwashing. So I think it's important, we have within the bank a regulatory team that obviously will update us on any changes, any disclaimer that we need to put in our offer materials. So that is important. And the last point is tax. Tax is very important in an international context where we do cross-border transaction. So we need to comply with the different relevant tax law, whether VAT, withholding, FATCA, etc. So yeah, in a nutshell, this is what we implement within the bank.
Great, thank you very much. If one follows all your rules, then the institution is safe. So that's definitely something that is amazing. What I wanted to add to all of this is that what we see in practical life, I have the pleasure of teaching AML to non-banking financiers in the Netherlands. And the questions that are asked back home in all these teachings are, can you give us a checklist? Please give us a checklist so we can comply. And then we can tick the boxes and we're there. I would love to do that, but we can't. You have already mentioned that there are so many things that have to be taken into account, various parts, from tax over ESG and all changing regulations all the time. And also, not only regulations are changing all the time, even our highest court admits that the regulations on AML are not black and white. The assessment of risk is something subjective to the viewer. Also being the financial institution to having to make that call. Which risk is it? Which category do we have to put this customer in? This is a subjective norm where there is no black and white, where there is no checklist, which means that you get into the gray area. And that is something that is very, very complicated to handle. For the banks, financial institutions, all companies that have to deal with it, and the customers. Because there is no grid, which is a security for both of them, where they can send from the beginning, this is what's going to happen. And that makes it difficult. And I think especially those gray areas are areas that have to be discussed in the relationship between the company and the client. So both of them understand why additional questions are being asked, because that's the outcome. Additional questions are being asked, even if the customer has filled in everything. And that's where they get annoyed and irritated and things are being stuck. So the awareness from both sides that there is a gray area, not because it's legal or illegal, but because of the subjective norms, is an important thing and a takeaway for both ends to get into this discussion in a way in which there is more understanding for the questions and for the answers. And once that is clear, then the due diligence is much easier for both sides of the table.
And I think there is a lot of educational work. So for example, clients in the Middle East want to understand why some EU regulations are applicable to them, for example. So, so we need exactly why GDPR, where we have, a local law, data protection. So we need to take the time to, explain to them on how these laws may affect them as well.
And another thing which I find very fascinating, and it might sound a little controversial, is a lot of times we hear apply the most conservative law. I'm always on edge of that, honestly. It's because there are certain regulation which has, jurisdictional reach which go beyond the certain country. There are certain subjects which are much wider. It's not specific to a certain country. FCPA, GDPR, we can give some examples. But I think what is very relevant, and it's not specific to due diligence, us as compliance officers, us as legal officers, I think it is also important that while we bear a lot of laws, international, sometimes even if they're not applicable to us, but also see what is applicable in your own country. Sometimes we forget that. And we forget to, customize, or we'll just take the most conservative because it's easier. At the same time, I can understand if a lot of times, we have a very lean team. We don't have the luxury of time to customize it, to make it our own. We understand. But I think that's also a parameter of how mature your function is. If we get that time, which we never will, but if we do, I think we should, tilt towards understanding what is applicable, and especially if your laws are varying from one country to the other. So blindly applying should not be the case. It should be the case, okay, yeah, we don't have the bandwidth to right now customize. So as a stopgap arrangement, let me do this. But again, it should be an informed decision. It shouldn't be, just because X law seems more glamorous, we'll just apply to it. Another aspect, and law can be glamorous, another aspect which I find very fascinating is, while we do good due diligence, we might have beautiful due diligence process, we forget to have as beautiful onboarding. You can be the pitch perfect vendor, you can be the pitch perfect organization that is getting acquired. But if you do not have a robust onboarding, your entire hard work of doing due diligence, checking the reputation, if it doesn't fit with you like a puzzle piece would, I think the entire exercise goes to waste. And, again, by my own personal example, I was a part of an organization called Zimmer Biomet. It's an orthopedic implant company. Zimmer and Biomet were two different organizations. Zimmer acquired Biomet, and Biomet had FCPA investigation. It was an informed decision. Due diligence was done. It was an informed decision. They did financial, everything that they had checked and made, accommodations for. But what we saw was it was more difficult to change the mindset of the acquired company than actually that homework of due diligence. So it is very important because due diligence is a continuous process and it is not end all. It is just a starting point. So we need to ensure that we do a proper onboarding, that culturally we are able to imbibe that organization or that vendor, and also keep that due diligence continuous or evolving.
Yeah. Before we get to eventual questions, maybe one of the questions would also be, yes, please.
Audit committees. But given the benefits of acquired, what to care of into having.
Okay, let me start with your first question, thank you, with respect to how can things go wrong if all these processes are good in place, right? Well, that's an organizational question because you can have as many regulations in place as you want. If they are not obeyed by the organization, then apparently there is no internal control on whether they are compliant or not. But that's what we see regularly because also it's the same thing with agreements in general, not only compliance in-house. You can have the most beautiful agreement between the parties, but if they do something else then the one on paper, it can have enormous consequences, namely, for example, living a completely different agreement than is on the head of your agreement. Let's say the most extreme one is having a freelance agreement, but having an employee. That's something that everybody understands. The consequences of having a freelance contract with somebody, but having somebody basically employed, has consequences on social security, taxes, and so on. But you can write on the paper whatever you want. If in practice it's different, this is what counts also once you get to a court of law. Same thing with compliance in-house. You can have the nicest compliance paperwork, but if the organization doesn't make sure that everybody obeys to it, well, then the organization has a problem. That's part number one. The second question with respect, there I would like to see whether I understood your question correctly. Is it that the regulator should scare off companies or that the companies should scare off the regulator?
I think both really, but more importantly, it seems that, as you've just said for part one, if institutionally the policies are not being applied and people are not being scared to do the right thing, then that's when your breaches are going to happen. But if regulators are not strict and giving you more fines or people are not going to jail, then organizations are like, well, this is a risk we're willing to assume.
Yes, I fully agree. And not only that, there are, if we look at the fines by the regulators, it seems as if they are examples set for the market that things are not happening again. But then on the same time, we see that so many things go unpunished for whatever reason, that the punishment goes to companies where it is easy as regulator to set an example and have high fines. Where I mean, if we look at Meta, for example, or other big organizations, that the regulators cannot go without to punish them, to set an example, and then it is highly unfair, as you state, in a way, in which companies that spend a lot of money, not only money, but time to make sure that they are compliant, are not, don't have the benefit of it, where others have more money to, hide whatever they're doing, they get away with it, and that's extremely frustrating, and there should be done more about it. One of the things that we can do is just, for example, like Bank did in the example that I said before, which is very courageous. Fight against it, go to court, take a lawyer, and make them see that what they're doing is wrong. And there, we as lawyers have an important role to play to help them, not against all odds. We have to be very careful in what we do, because if it gets ridiculous what we're doing, then it's the wrong example. But we should definitely be with the courageous that fight the system in order to make sure that compliance is something that everybody has to obey to, and that the regulator has to adapt from that point as well. Because from this AI-driven bank example, the Dutch National Bank, as regulator for the financial industry, did rethink their way of doing it. So it does make sense, it works, but you have to have the courage to go against your regulator as an institution, and we as lawyers should support them diligently and in a good manner.
Yeah, but most of the time the reputation will be already affected, so yeah. That's, yeah, it's a shame.
Another thing I'll add, and I absolutely am aligned with what Edith said, is one of the links that are always, I think your first question, what I have seen is sometimes we might have 1,000 processes for due diligence, one by finance team, one by compliance team, one by legal team. And a lot of time they don't talk to each other. So that's a big missing link. Everything is confidential, everything is privileged, but then you're not talking to each other. That's one thing. It's not processes, it's how these processes talk to each other, and they're practical. I think that's another point that Edith was saying. The second is, I'll flip your question, not to scare organization, but to sensitize the organization. I think that's more important. Being scared doesn't get you anywhere. That's my view. Sensitization of the organization, and organizations have become very sensitive, because every time you see any I wouldn't say regulation, but these recommendations that come from DOJ, SEC, these recommendations have been putting a lot of emphasis on due diligence. Second, if you see FCPA investigations, they say, okay, you did due diligence, but what did you do after that? That's where I was talking about onboarding. Third, which is very important, is constant conversation between organization and regulators. Because there's so many things which are very specific to an industry. What may apply to banking industry will not apply to healthcare industry. So it is very important that we have these conversations with regulator, and we both need to keep an open eye and ear. It cannot be a one-way traffic.
Thank you so much, guys, and thanks for the amazing session.